based on your response, doesn't reading this Section 28 summons and the detail contained therein as regards what IDAC wants, have we not crossed the line of interference? Is this not interfering with the affairs of SAPS as law enforcement agencies in circumstances where IDAC doesn't know, at least from these summons, why that particular individual was arrested? Is this not rendering SAPS accountable to IDAC for decisions that SAPS takes? And if so, what would be the statutory entitlement to that?
It does not make sense at all. And that's why I said that there's no requirement, there's no legal requirement. They may have used a legal document to procure this or attempt to procure this, but there's no legal basis for the existing investigations in IDAC where Mr. Adams made the 27 referral and however many supplementary A1s. It cannot take the matter further, knowing who arrested him, why they arrested him, and so on.
So would it be fair then, based on the face of this document and your responses, I take it you have no knowledge of the summons, you never authorized the issue of such a summons?
Correct.
So the commission must turn to the person who signed it, which is Advocate Manilal, together with his investigator as reflected at page 3527, Mr. Brian Padiachi, who's the senior investigating officer. The answer must lie between the two of them.
Correct.
We shall do so. Thank you.
Maybe just to complete this, you will see in the last 2 pages that the SAPS does indeed respond, and now we know Mr. Manilal and IDAC have the names of the people that effected the arrest. You see that at page 3532 and 3533. So whatever purpose he sought these names for, he has now been given the names, and maybe he'll come and tell us what he did with the names. Okay, thank you.
And having worked through these documents, did it happen often when you were the ID that investigations are initiated without your knowledge? You will recall that, I think when we started our engagement last week, I had expressed a concern that it sounds like everyone within IDAC was on a frolic of his own and running their own show. And this is one such case that brings that to the fore. I want to know, are there many of such, to your knowledge, that are perhaps lying about in IDAC? If this particular summons is anything to go by, I would suggest that they should be.
In all fairness, Chair, there's the teams work within a very structured approach with their matters. They won't come to me with every Section 28, but the 28 has to have purpose. And I haven't stumbled across one where even when we have a discussion, then it's out of sync. Sometimes they may have asked for something extra or something less, but it is within the framework of what they were allowed to ask in order to further that investigation. And where I have to make a slight qualification is, I'm not sure what drove this, and so they would have to answer, why would we need that information? Where does it take the Adams complaints, regardless of whether we've put them now to the side and whether the Section 27 is substantial, insubstantial? What will we do with this? What do we do with this?
Where could it possibly take the Adams complaint?
Nowhere. As we have it,
yes.
Nowhere. And that's why I'm saying, they've now, Commissioner Baloyi has shown the last 2 pages. Having all these names and knowing whether approval was granted or not, knowing whether it cost 5 cents or 5,000 rands, does not take the Adams matter or matters any further than before he got arrested.
And knowing who from PKTT effected the arrest as well.
Yes.
Doesn't take
The matter any further.
No, so is it your testimony to this commission that this actually was the first time such occurred? Can you confidently say so? And if the answer is potentially yes, what would give them, should I say, the strength or the bravery to do just what they did in May 2026? How do you lend there as the ID? And I will add to that, if I may, You've been in ID for a few years. If you were in office, what would be the consequences of this?
Well, first of all, they would have to explain why they went off investigation. They'd have to show where it was in the investigation plan.
And where does that help you if they've gone off
And
investigation?
if they have gone off investigation, then steps would have to be taken because
No, I apologize. You start by saying why they went off
Yes.
investigation, and I'm saying the why is irrelevant. As based on your and my discussion, we've established that there was no such investigation that can justify this summons. Now, I'm interested in consequence management.
So in terms of the consequence management, either I'd have to first determine if this was the first time, and hope to God that it is. But if it is, then it is a matter of him being given a written warning, or this actually, in this way, and now that we do have the IDAC judge, is to perhaps refer it there because this is irregular and unprocedural in the manner in which it was done. It didn't have a... We kept talking about the Section 27 as a basis for things. Where's the basis for this? So what is the process you follow when you don't have a basis? And why did you embark then on a process that isn't allowed when you do not have a registered, whether it is an inquiry or an investigation or an authorized matter? And that would be something that would have to be escalated for an investigation outside of the framework of IDAC, which is the IDAC judge.
Is the truth
Sorry.
Without taking issue with Ms. Silo's focus, I want to suggest to you that the why is actually relevant because these many, and underline many, departures from the norm may actually be symptomatic of improper motives on the part of IDAC. Do you accept that suggestion?
I accept the suggestion.
Thank you.
Thank you, Chair. And if I may just go back on what you said, is this a question of improper investigation or outright unlawful? It's an unlawful investigation, if not in terms of Section 27 and Section 28(1). We settled that on the first day. So how do you even suggest giving a written warning for unlawful conduct? IDAC is a super powerful institution. It's the only institution in the country which has got the power to both investigate and prosecute.
That is why I corrected myself and said, actually, this matter must go to the IDAC judge because you must first look at the basis, and there is no legitimate basis. Therefore, process of IDAC has been deviated, and for the judge to then...
Where is the ID in this? At which point the ID institutes at least disciplinary proceedings with a view to terminate the employment of these people who abuse the immense powers held by IDAC to do what they did here in Section 28. Why must the judge deal with those issues?
So in terms of the disciplinary processes for IDAC, they now resort under the judge. Judge will look at it. Judge can then recommend to the Labour Department. Ordinarily, Chair and Commissioners, we would send it to two places, Office of Ethics and Accountability and to the Labour, and they would run the parallel matter. With IDAC, the IDAC judge oversees the IDAC staff. He is the first port of call. You refer matters to him. He can then decide, look, we're going to proceed on this part, look at criminality. In the meantime, Labour, you can institute action because this is clearly a Labour issue. But it is looked at holistically, and the judge engages both the Office of Ethics and Accountability as well as Labour. But he is the final arbiter and the conduit through which these matters go.
Can I just add that it's not just irregular, and I think you will agree with me. It's not just irregular. It is in fact an abuse of the Section 28(6) and 7 power and process. So it's much more serious than an irregularity. An irregularity can be, some irregularities can be condoned, can be excused with an I'm sorry, I misunderstood. But this is an outright abuse of a process that is prescribed by law for ulterior purposes. You accept that?
I accept that,
Yeah.
Commissioner.
Thank you.
Thank you, Commissioner Baloyi. And you, on the first day of testimony, you touched on this section, Section 29, capital A, which reads, an investigator may, subject to the control and direction of a head of an investigating directorate. In this instance, where is the ID's control and direction? When you have a patently unlawful Section 28, presumably informed by an unlawful investigation, and your solution is to direct it to the judge. Where do you exercise that control and direction? Unless it has to then be accepted that that investigation was done, that unlawful investigation was initiated and implemented with the concurrence of the ID, because the solution that you offer somehow takes the head of the investigating directorate out of the picture and absolves them of responsibility. Yet the very section you relied upon, I think on your first day, Section 29, capital A, sub 1, says every investigator may, subject to the control and direction of the head. Where do we find that control?
In this instance, we cannot look for the control of the investigating director because it is done without the knowledge of the investigating director. So I had no control over this situation.
So the ID failed to exercise control over the institution.
The ID cannot fail to exercise control over that which you did not know. It has now come to my attention, and then we exercise control in the manner in which I suggested, commissioners, that it then be escalated to the IDAC judge.
Okay, I would like to move off this topic to a slightly different one, and for that purpose, I would invite us to go to file 3, where we are in the ad hoc transcript. I think I'm not closing file 9 yet. No, I'm not. In particular, please go to page 586. And midway there, page there, this is an engagement you had before the ad hoc with Mr. Ngola. And I'm reading from, I think, literally midway, where it says, there is an allegation, Mr. Ngola says, there is an allegation that IDAC actively participating in a well-coordinated attack against General Mkhwanazi, General Masemula, and General Khumalo. Are you aware of that allegation? To which you respond, I've heard the allegation. There is no truth to the allegation. There are criminal matters that are in the IDAC space. If all that IDAC wanted to do was to go out on a witch hunt, nothing precluded IDAC from arresting and placing both Generals Mkhwanazi and Masemula on the court roll when I took office in 2022, or any time from then till now. We did not do that because there was not sufficient evidence in the matters we have. There is also no witch hunt against Lieutenant General Khumalo because there were no matters brought to IDAC prior to the referral by Mr. Adams. And Mr. Ngola asks, do you not think the manner in which the IDAC responded to Mr. Adams' complaints is actually feeding that narrative? Now, what we dealt with in the morning, in large part arises from yesterday, Mr. Adams's complaint, and including this latest Section 28 summons against PKTT, which you had denied that IDAC was investigating, and it turns out that it was. Surely, with the wisdom of our, this is the commissioners and myself engagement with you, you must accept that Mr. Ngola was right, that the manner in which IDAC responded to Mr. Adams' complaint, at the very least, is feeding the narrative. And based on the evidence, I'll suggest that the narrative is actually true, that there appears to be an active, coordinated attack, at least against General Khumalo. That much we've established. General Mkhwanazi, not yet, but to the extent that he is associated with PKTT, perhaps. General Masemula, we haven't canvassed that. What would your comment to that be?
Yes, I think that if we look at the matters in their totality, and we also look now that this one, Commissioners 3527, really bothers me. Then the assertion that, or the conclusion you draw, makes reasonable sense. And whilst it didn't, and in all honesty, at the time, what I said is exactly how it was. And as you look at some of the things that have now come out from parallel statements, et cetera, there are dots to connect, unfortunately.
Yes.
It's not just 3527 that feeds.
Sorry, Chair.
It's not just 3527 that feeds into that suspicion. There's also the summons that you signed,
Correct.
where there doesn't seem to be any basis for the inclusion of the PKTT. So that's another dot that feeds into the suspicion of the PKTT being targeted. You accept that?
I accept that.
Thank you, Commissioner Baloyi. Staying with the transcript, let's go to page 592. The same point is revisited by Ms. Sangoni. And Ms. Sangoni inquires from you, Advocate Johnson, were you saying that you are investigating General Masemula and General Mkwanazi, or you investigated them and found no evidence? Your response, to be clear, there was an investigation in which both are implicated, a matter arising out of IPID. There is insufficient evidence for me to move against the both of them. I'll pause there. My first question, what are these matters arising out of IPID, and what do you mean they arise out of IPID?
Council, when you and I consulted, I did indicate that when I first took office in March 2022, there were already some IPID investigators at the then ID, and they had come over with their matters. I sought to find I just want to find a letter that I can ask that it be shared. If I could just first indicate what the letter says, commissioners, and then I will hand it over for them to just make copies. I did indicate to council that when I took office, there were IDAC personnel and IDAC matters in IDAC. But it had been borne out, Chair and commissioners, by a letter written, and this was the only document I could get, and Mr. Sissoko did look for other documents, but he was part of that process, and he would be able to elaborate if there's a need. But my predecessor wrote to the acting executive director of IPID on the 31st of October 2019, wherein the gist of the letter is that there are matters currently in IPID that fall within the mandate of IDAC. And in terms thereof, certain cases have been identified, and the request is for those matters to come over to IDAC together with the investigators who had those matters. At the time, in 2019, we must bear in mind that the ID was created by proclamation. It is not permanent. It is unable to recruit investigators permanently. And so any investigators the ID would have required would have been what they call secondments or duty reassignments. So she asked for these matters to come over and for those investigators to be brought with those matters. And in fact, investigators did come over with the matters that they came over with. And this is the one letter that I could find where the request was made and to whom the request had been made.
Just for the record, who's the author of the letter and who is it addressed to?
It is addressed to the acting executive head of IPID at the time, and it was addressed by Advocate Hermione Cronier, who was the investigating director, commissioners at the time.
Do you know who was the acting executive head of IPID at the time? Does the letter say?
Make copies. Sorry. Apologies.
We can pause.
We'll pause that one. Yes. But it would say, from what I then found out, that exercise did in fact take place. And so when IPID came over, they came over, council, with matters that would have dealt with corruption. And in the main, because they are IPID, it was corruption matters in the South African police services. And much of these were, Commissioner Baloyi, supply chain management issues, corruption, PFMA, and all of those things.
Okay. It brings me to a question about which could have been asked much earlier. And it's a question about how IDAC takes over matters from other agencies, matters that fall within the jurisdiction of those agencies. So you took over dockets, for example, the Orlando dockets, the Langlaagte dockets, all of those, they do fall within the jurisdiction of the SAPS.
Correct.
You took them over and investigated them. Now we know that IDAC, in its former formulation, took over matters from IPID, which fall within the jurisdiction of IPID. I imagine there are matters which fall within the Hawks. I don't know if you've taken over any, but which also the Hawks is quite fair. Surely there must be a protocol that even if it is a common understanding, not written down, but an understanding amongst the heads of the agencies about what that regulates that ability and power to summon and demand or request, if you like, matters that are sitting, and properly so, with another agency. What is that governs that, and that would have enabled you, for example, to demand, and I use the word demand quite deliberately, to demand the files from SAPS, to take over the files from IPID?
I think it's the protocols with which we had worked over the years, and it became accepted practice. But I do believe that in some instances, and I do speak under correction which ones, there are also memorandums of understanding or service level agreements, just to ensure not just the smooth working, but legitimacy for why we are asking from somebody else. So across the board, there are those working relationships. There's even, for example, a tripartite between SARS, the NPA, and I think the SIU. So they have that.
Yeah, I guess what I'm asking is it a function of, oh, I like this matter, IDAC likes this matter, which IPID is perfectly qualified to deal with? Is it simply IPID, can decide we like this matter, and so we want to take it over, and you write to your counterpart, and you say, bring it over, and they have to bring it over because that's the governing rule? Or is it much more nuanced or much more sophisticated than that, as in it must relate to something that you are dealing with, so you don't just go about fishing for people's dockets, but it's related to something that you deal with?
Correct. So if one looks at the letter that my predecessor wrote, she did set out why those matters should come to IDAC. And I would assume that if the counterpart to whom she wrote felt, we get you, but we're on it, we're good. If we need resources, we'd rather ask you for resources, but we're good on ours. They didn't do that. They gave over the matters, plus they gave over the investigators, their very own resources, to come and do the investigations in the then IB.
Thank you. We'll see when the letter comes back. Thank you.
And it's gone for copying. Thank you. Let's agree on one thing. The files and the investigations are owned by the institution, which has the mandate to investigate. No investigator owns any investigation.
Correct.
So must I take it that the letter, when it does come, is going to specify which matters precisely are transferring from IPID to IDAC, or it doesn't specify which matters, therefore leaving it open to what you often refer to as their matters for the investigators themselves to determine, I like this file, I'm taking this one. What must we expect from the letter?
In this letter, which was the only one I could find, was where she wrote to them, said why it should be in the IDAC mandate, and then identified certain investigators that must come over with the matters. I guess then those investigators already had specific matters that she had identified fall within the mandate, and they would have come with those. Mr. Sissoko and I tried to look for any other engagements. In fact, he did call IPID to see if they could find their letter where they then say, these persons are coming over with these matters. We don't have that letter. But we have the persons who came over.
Your response also seems to place emphasis on the investigators and their matters. My question places emphasis on the matters. Does that letter identify them? Because when IPID was seized with those matters, it had the mandate to investigate. The establishment of IDAC and acquisition of certain power by IDAC did not strip IPID of its original mandate, as I understand the law, unless you can show me a provision in the Act, in any Act, that stipulates that henceforth the nature of these matters will fall strictly within the purview of IDAC only. I'm not aware of such. So if it had the authority, even after IDAC was established, it retained the authority. So I'm trying to understand how the investigation then transfers to IDAC. That's why I say the emphasis cannot be on the investigators, it can only be on the investigations themselves. And that letter, I then expect, would have identified the respective investigations that IPID transfers to IDAC, because having effected that transfer, then IPID no longer bears responsibility for the further execution of those investigations and acting upon any outcome.
If I could just look at the...